As we get into the room here, I just want to have some basic reminders. This webinar is brought to you by Cure. We'll talk a little bit more about Cure in a bit. The recording will be available in the coming days. We'll put it up on our YouTube and probably likely sent out an email to folks who have registered so that they have access to that recording. There will be a Q&A session at the end of the presentations if I don't talk too long. And information is provided for your own use, but is not legal advice. And if you do need legal advice, you're going to have to consult a lawyer who can represent you, but Cure is not able to do that. We have this as part of our webinar series we've been doing since December. I believe this is the fourth out of 5 webinars on data centers in Minnesota. So please do check out our recorded webinars and think about registering for our upcoming webinar. And yeah, I guess we are 1 minute in. So as I said, we should get started. Today is data centers and environmental review. And in the future, we will do one on data centers and community benefit agreements. What can be done if there is going to be a data center in your community and you want to make sure that it's a fair deal. Cure, who is your host today, is a small rural nonprofit in Minnesota. We've been around for about 30 years, more than 30 years. And Cure protects and restores resilient communities and landscapes by harnessing the power of people who care about them. We work very much on rural environmental issues with rural communities, and we are strongly in favor of democratic processes that include people in the decisions that affect their lives and affect the landscapes and places that they call home and rely on. This is, of course, a free webinar. And if you like what you see, consider supporting Cure and our work towards a thriving rural future. I'll also say at this point that this webinar you're about to watch is eligible for continuing legal education credit, CLE credit. And if you are a lawyer watching this live, the code you're going to want is 543710. That's how you'll be able to find your CLE credit if this is approved by the board that makes that decision. And we have every reason to expect that it will be. For everybody who's watching and is not a lawyer, congratulations, you're practically a lawyer. But again, that's not legal advice. And don't say to anybody that I said you're practically a lawyer, because that could get me in trouble. Who am I and what am I talking about? Well, I am one of your 2 presenters today. My name is Hudson Kingston. I am legal director at Cure. I live up in Ely, Minnesota. And I work in a legal team with the illustrious Sarah Mooradian, who is our government relations and policy director. And you'll be hearing from Sarah later, but I'm just going to forge ahead if that's all right. Okay, so what are we talking about today? We're talking about environmental review. And in Minnesota, the law that governs environmental review is the Minnesota Environmental Policy Act. Please don't say the Minnesota Environmental Protection Act. You will upset me more than I can say. It is not right to call it the Environmental Protection Act. In fact, it is a policy act. It is about procedure more than it is about substance. While it helps us to protect the environment, it does not by itself protect the environment. It is administered by something called the Environmental Quality Board, which is a Minnesota state agency, and we have their website up here. A lot of the materials we have, including the graphic I have here, are from their website. And they write the rules. So the MEPA rules are Minnesota Rules Chapter 4410. And that's where you would go if you really wanted to dig into the details of environmental review. In my opinion, it's just about the best law we have. It's 53 years young, so it's been with us for a long time, and it's protected a lot of people from a lot of things over the years. And it's very similar environmental review to other environmental review laws. There's the federal NEPA, National Environmental Policy Act, and actually 20 other environmental review laws across the country. Most of them are at the state level, but there's one in Puerto Rico. There's one in Washington, D.C. The city of New York has one. And I believe there's a regional one in part of California. So it's mostly at the state level, but it can be at the city and regional level too. And of course, territorial when you talk about Puerto Rico. And for the term for all of these and the term for our webinar today is environmental review. So this is one of my longest paragraphs, and I'm sorry about this slide, but it really contains everything you need to know. So what does MEPA require? When there is the potential for significant environmental effects resulting from any major governmental action, the action must be preceded by a detailed environmental impact statement prepared by the responsible government unit. The environmental impact statement must be an analytical rather than an encyclopedic document that describes the proposed action in detail, analyzes its significant environmental impacts, discusses appropriate alternatives to the proposed action and their impacts, and explores methods by which adverse environmental impacts of the action could be mitigated. The environmental impact statement must also analyze those economic, employment, and sociological effects that cannot be avoided should the action be implemented. To ensure its use in the decision-making process, the environmental impact statement must be prepared as early as practical in the formulation of an action. So, as you can see from the emphasis, the parts that I really want to focus you on are that it is triggered by the potential for significant environmental effects resulting from any major governmental action. That's fairly broad and comprehensive. It must precede any action by that government entity, and it must do a full analysis of the impacts of appropriate alternatives and mitigation of any harm that will result from the action. It's not just about the environment, it's about economic and sociological impacts as well. And it has to be prepared early enough that it's actually useful. So, at its core, a very simple law. A major government action which potentially impacts the environment gets you an EIS. But even if it doesn't potentially impact the environment and you're not sure, you still do an environmental review, even if you do not know for sure if there's the potential for environmental impacts. And then within, as I said on our last slide, it precedes the action. It includes all environmental impacts, but also social and economic impacts. It requires the analysis of alternatives and exploration of actual mitigation that would stop pollution from happening. Now, most environmental review laws, including our national one, are not substantive. That is to say, they don't require you to protect the environment. They just require you to analyze what the impacts are. But MEPA has a couple of small pushes towards actually protecting the environment. One of the big ones is regarding the alternatives. And it says that economic considerations alone cannot justify picking an alternative if it is more harmful than another available alternative. So if you are in somewhat opposition to a project, perhaps it's an open pit mine that you don't like, and you draw up a new mine plan for a totally underground mine, and you say, here you go. You are a mining company. I'm smarter than you. I've come up with a better alternative. And it gets analyzed in the EIS, and ultimately the mining company says, we want to do an open pit mine because it'll make us more money, because it'll be cheaper to do an open pit mine. MEPA would say, if that's your only justification, then no, you're going to do the more expensive option. You're going to do the thing that mitigates the harm. And then additionally, there is a sort of preambular section in the statute in 116D03 subdivision 2 that actually requires state agencies to do quite a lot of things. And they are really to consider doing things and use interdisciplinary approaches in order to better understand the impacts of certain environmental choices, I should say. But there are substantive requirements in the law, which is sort of exciting because normally environmental review doesn't have that. One thing that's very important to get a good environmental review is to make sure it's the right size. And we call that scoping. So the size of the review should be tailored to fit what the government is doing. If it's a local or regional project, you would assess the local or regional impacts. If it produces greenhouse gases or some sort of large impact that goes around the whole planet, then you're going to have to analyze that larger impact to the global climate. If it emits, for example, forever chemicals, which last forever, then the review should be the correct number of years to match the duration of the harm and impacts to the environment. And even if you have scoped your environmental review to be very small and local, you still have to include cumulative impact analysis. And that is to say, my project might only pollute a teeny tiny bit, but it must be considered in the context of the larger amount of pollution and impacts in the world. So, for example, if you're going to put wind turbines off the coast of Maine, you cannot do an analysis of just what the wind turbines will do to the endangered whales in the area. You also have to discuss what the lobster fishery is doing to the whales. And because the lobster fishery has such disproportionate impacts on the whales, your project will be assessed in that larger context of an already stressed resource that's already on the brink of extinction, which, you know, as a project proposer, I don't think is fair, but it's a realistic assessment of what's actually happening to the resource and to endangered species that are listed by our federal government. So before getting to an EIS, before getting to the gold standard biggest review, often and most of the time, responsible units of government are going to do something called an environmental assessment worksheet. And it is a simpler review that nonetheless it covers all types of pollution and most types of known impacts. And it is meant to be the form and basis for a decision on an EIS. At the end of completing an EAW, the responsible government unit has to decide, yes, we are going to do an EIS, or no, we don't have to do an EIS because we've determined there is no potential for environmental effects. In practice, an EAW almost never in Minnesota leads to an EIS. Most of the time, an EAW is completed and it gets a negative determination and not an EIS. And generally speaking, there are about 5 EISs in the state of Minnesota per year, maybe less than that. But there are far more EAWs than that. Those are happening all around the state all the time, very much so at the local level. An EAW can also be a part of an EIS process. It can actually help to scope and determine how big an EIS would be and what importantly the main issues are for an EIS to cover. So this is just sort of looking at literally what does the EAW work look like. It is quite literally a worksheet that the government has prepared that you can just fill in the blanks on. It can feel like a game of 20 questions, but it's actually 22 questions. Haha. And it includes cumulative impacts. You either have to assess cumulative impacts throughout all of your answers, or there are catch-all questions at the very end that say, what are the cumulative impacts of what you're doing? So if anyone tells you that EAWs do not assess cumulative impacts, you tell them they're wrong because it explicitly covers cumulative impacts. However, it does not require an analysis of alternatives. So it really is the project proposer's alternative. They're what they want to do against not doing that, which often is not a very satisfying way to actually solve a problem. It's not a good way to come up with a better solution. It's just a straightforward analysis of what a project proposer wants to do. And often there are projects on the horizon that likely could use that type of analysis. So Minnesota has a formal standard written into the rules on how communities can petition for an EAW. And again, I said I wasn't going to give you long paragraphs. I sort of lied. This is the first half of a paragraph, and the next slide is the second half of a paragraph. But it's important to know about. So an environmental assessment worksheet must also be prepared for proposed action whenever material evidence accompanying a petition by not less than 100 individuals who reside or own property in a Minnesota county, or where the proposed action will be undertaken, or in one or more adjoining counties submitted before the proposed project has received final approval by the appropriate government units demonstrates that because of the nature or location of a proposed action, there may be potential for significant environmental effects. For several data centers and many other types of projects in the state in the last few years, there have been these types of petitions. And specifically, it has to have material evidence about the potential for significant impacts. It has to be signed by 100 Minnesotans or people who own property in Minnesota. And specifically, the legislature recently changed the law to not be anyone in the state of Minnesota, but rather you have to be in the county where the project is happening or an adjacent county. So that makes it a lot harder in rural areas to get your 100 signatures. This was the legislature making it a lot harder for rural people to access this type of justice. And you present that material evidence in your petition with your 100 signatures and verified addresses. And you are trying to make the case that there is the potential for significant impacts. Keep in mind, you don't have to prove that there are significant impacts. You don't have to be certain. The law says potential for significant impacts. The second half of that paragraph, continuing, petitions requesting the preparation of an environmental assessment worksheet must be submitted to the board, so the Environmental Quality Board. The chair of the board must determine the appropriate responsible government unit and forward the petition to it. A decision on the need for an environmental assessment worksheet must be made by the responsible governmental unit within 15 days after the petition is received by the responsible governmental unit. The board's chair may extend the 15-day period for not more than 15 additional days. So yes, you submit your petition to the EQB and they assign it out to the best entity to do that. Often for data centers and other projects that seem to be more local, it gets assigned to a local unit of government. If it is something for which a state agency has a permit, it would get assigned to that state agency. So when a petition goes in on a pipeline or on a power plant, the petition gets delivered to the Public Utilities Commission. But if a petition is submitted regarding a gravel pit or a data center, it goes to the local unit of government, which could be the county, it could be a city, it could be a township, but probably not a township. It'll probably go to the county instead. And then there's very little time to make a decision. It's up to 30 days. And it can really stress the ability of a governmental unit to have to make this decision and also comply with the open meetings law, because they have to make the decision in an open meeting. Meetings have to be scheduled ahead of time. So this definitely starts a stopwatch and it creates a 30-day procedure that has to be taken care of pretty quickly. So as a result, EAW petitions slow things down a bit. They are like a speed bump where you better slow down, because if you don't slow down, you're going to wreck your car. When there's a pending petition, the subject of the petition cannot be approved until the petition is resolved. So if there's a permit to be issued or something like that, the permit cannot be voted on and issued without a resolution of the petition. And then if you have submitted a petition and there is no applicant, or there's no clear intention to issue a permit in the near future, then that responsible government unit has to hold on to your petition for the next 12 months and is blocked from issuing permits during those 12 months on any project that is described by your petition. So it sort of exists for the next 12 months. And to the extent that a project goes 366 days, the person who submitted the petition should probably just resubmit every 364 days to be certain that they have it on file with the relevant government. Now, within MEPA, there's also something called mandatory categories. And I think it's totally interesting and useful that we have them. And I also think it's a misnomer and not helpful, because these are thresholds above which you have to do an EAW, or thresholds above which you have to do an EIS. It creates a misnomer because people call those mandatory EISs or mandatory EAWs, but the law still requires you as a requirement that is mandatory to do what is called a discretionary EAW. So in this case, discretionary EAWs are still required if there is a potential for significant environmental impacts or if there may be the potential for significant environmental impacts. Both of those are still required, but they get called discretionary, even though they are not optional. And you can see from my graphics here, there are mandatory categories for warehouses and factories, for things that we know about, for technologies we're aware of, not necessarily for new types of technologies and new types of impacts. And that's why I'm going to repeat myself and say review can still be mandatory under the law, under MEPA, even in the absence of a mandatory category. And this is especially true for types of projects where the EQB and the legislature do not have any experience with that technology or the impacts it may cause. Often you cannot establish a category without actually understanding examples of that category. And the photos I have here are of modern data centers versus what we had in the 60s and 70s. I mean, having a few tape reel machines around in a room in a university lab is not the same as having hundreds and hundreds of diesel generators lined up outside of here is a data center in Arizona with giant amounts of potential diesel generation. And these are just orders of magnitude different. So the fact that there isn't a mandatory category does not mean that you don't have to do environmental review. It just means that what you're dealing with isn't a settled matter according to the legislature or the EQB in its previous rulemaking in the years preceding now. Now, I'm describing an EAW as a fairly straightforward and easy process. It still has a lot of steps. It still has a lot of procedure. This is a flowchart that the EQB created. There are many steps to get through in the relatively short period of time given. And some interesting things about the steps: the project proposer produces most of the information. So while there is a responsible government unit, they're not doing all the science themselves. They're getting that information from the project proposer. There are really tight timelines once the submissions are made of 5 days here, 5 days there. At numerous stages, the information is publicly published in the EQB Monitor, which is the EQB's way of letting people officially know that some environmental review document is open for comment. There's only a 30-day period mandated by law for public comment on an EAW, and having a public meeting is optional. And yeah, it's a lot of procedure, it's a lot of steps to go through, and the substance is really important, but that is not what the focus is often of the government unit that is trying to jump through these hoops and make sure that they get all these things done on the timeline that they're given. By contrast to the EAW, which I think is much more of a known quantity here in Minnesota, just talking a little bit about EISs, I want you to know that as far as we know right now, there has been one environmental review at the EIS level in New York State, and it's regarding crypto mines, so a type of data center. And in that case, they did a draft generic EIS. So it talks about these types of crypto mines generically, not at a specific site or location. And they've only gotten to the draft phase. They have not gotten all the way through with their analysis. They started in 2022. And as of last summer, they had a draft EIS out for comment. That's available, and it's interesting to see because other than that, we have not been able to find a single EIS on a data center in this country. And as I said, there are state level EISs. Many data centers have been built in California, as far as I know, and I have not yet found an EIS level analysis of any of these projects. That said, we do know, as this screenshot of a press release says, there are probably going to be 16 federal sites on federal land where they're hoping to site data centers in the next year. And for those, I would expect that they will do an EIS. It seems likely that they would be required to do an EIS under the federal standards. But I have not seen any such analysis from the Federal Department of Energy yet, which is who did this press release. Why would you want an EIS? What is the benefit of an EIS? What does it entail? Well, just to be very quick about it, an EIS provides a comprehensive analysis. It requires the analysis of alternatives and mitigation, so different ideas and ways to get rid of potential harms. It requires whoever is making the decision to consult with other expert agencies. It requires the consultation of wildlife agencies specifically about endangered and threatened species and how they may be impacted. At the federal level, it would require consultation with tribal nations. And I believe that at the state level, it should also require consultation with tribal nations, although the rules around that are not as clear as they should be. It requires, as I said, cumulative impacts and climate assessments and economic and social impacts that go beyond just what we might call the environment. The photo here is Minnesota State Bee, the rusty patch bumblebee. And many of the data center projects in and around the Twin Cities and its suburbs could easily be held up for impacting our endangered state bee, whose relevant habitat is very much clustered around the Twin Cities area. So, I mean, having a proper environmental review allows you to make sure that a project isn't going to kill off the state bee, which I think is valuable. What is beyond an actual EIS? Well, the EIS does not make a substantive decision on any permits. It does not say yes or no to the project, and it doesn't delineate how community benefits are going to work out. But it does give context for all of those things. So it's very helpful, even when it is not actually making a decision or showing the government's cards on what decision they plan to make. So I showed you one flow chart for EISs. Obviously, perhaps not obviously, it's even more complicated than that. So this is just the flow chart for scoping an EIS. It has more steps than an EAW. It has more opportunities for public comment. On this, just in the scoping phase, the reviewers have 30 days to submit written comments. The responsible government unit hosts at least one public scoping meeting. Many projects I've been aware of, they host several. They do them online. They do them in different affected communities. These are just minimums set by the rules. And then actually preparing first the draft EIS and receiving comments on it, and then preparing the final EIS are also a more rigorous system and more significant analysis than we saw in that first flow chart. So there's informational meetings, there's public comment periods, there's more than one comment period, and there is a requirement to respond to all substantive comments. So if you make a comment on an EIS, then the government has to respond to you, which is very helpful if you are trying to establish what you care about and make it clear that they've actually reviewed what you put in your comment. So that's what an EIS is for. That's why they're so great. And I will now hand it off to my colleague, Sarah.
Great. Thank you, Hudson. Just as a reminder, as Hudson said, I'm Sarah Mooradian, Government Relations and Policy Director at CURE. So we've already talked about the EAW and the EIS, but there are also alternative forms of review that are allowed under MEPA. So specifically, this is the statute for those who are interested, for those looking for your CLE credits. It's within MEPA. The key thing is that the alternative process must address the same issues and utilize similar procedures. And you can't just make up an alternative form of review. It has to go through and be approved by the EQB. Next slide, please. Perfect. So AUARs, alternative urban area-wide reviews, are getting a lot of time in the spotlight right now, especially because of how often they're being used for data centers or proposed data center development. So AUARs are really designed to assess the cumulative impacts of potential development scenarios in a defined geographic area. They're really about local planning to understand different scenarios. Local governments also have to have an acceptable comprehensive plan in place too. They can't just come up with an AUAR on their own. AUARs are only for residential or commercial development, warehousing, light industrial development, and then infrastructure associated with those kinds of development. Future projects in the area don't require additional environmental review if they are consistent with the development scenarios studied in the AUAR and don't independently trigger a mandatory EAW or EIS, like Hudson was talking about earlier. And despite their name, they are not exclusive to urban areas. We're seeing them being used pretty much across the state for data centers in particular, but they don't actually need to be only occurring in urban areas. Next slide, please. So under an AUAR, the environmental analysis that happens, the content and form must be similar to an EAW, but the level of analysis has to be comparable to an EIS for direct, indirect, and cumulative potential impacts. So I've heard and seen a lot of times an AUAR being described as a hybrid sort of between an EAW and an EIS. An important distinction is that no alternatives discussion is required under an AUAR. And I do just want to note, there are additional procedures that are required if a large specific project is contemplated and would otherwise require preparation of an EIS or would comprise at least 50% of the geographic area to be reviewed. I haven't seen that kind of thing really happen as so much yet in data centers, but just noting that there is kind of this, even within this alternate option, additional things that might happen. Next slide. So here's a timeline of an AUAR. This is kind of to help compare with the things that the flowcharts that Hudson previously showed you. So this is contemplated, this is discussed in Minnesota Rule 4410.3610. For those who are interested. So an AUAR only has one 30-day comment period contemplated in the rules. And then next slide. Importantly, only state agencies and the Met Council can object or file objections to the AUAR. That's really different from EAWs and EISs, where the public in general has an opportunity often to comment again after a draft EIS is published. Next slide. So in terms of data centers, what we're seeing with AUARs, they're assumed to be light industrial development. That's how they're coming in, because again, AUARs are only available for residential commercial development, light industrial, and warehousing, and then the associated infrastructure for those things. So they're being assumed to be light industrial development. The definition of light industrial in the rules is a subcategory of industrial land use with a primary function other than manufacturing and less than 500 employees. We're also seeing data centers often being referred to as technology parks in AUARs. Sometimes they are called explicitly listed, data centers are explicitly contemplated, but more often, especially in kind of some of the early ones that were released or published, they were just kind of named as technology parks. So data centers might trigger additional environmental review if they meet the threshold for a mandatory EAW or EIS. Those are the mandatory categories Hudson was talking about earlier. Based on our review of the rules, they could trigger additional review for their location and size. So in the rules, certain industrial, commercial, and institutional facilities, based on where they're located, a first, second, third, fourth class city, and the size of the development itself. So there's different levels. Based on square footage, it might trigger an EAW or an EIS. There might be some triggers for air pollution with an EAW, but as we'll talk about in a second, that would really be, it probably would be limited to just like on-site generation, not the data center itself, because the data center itself is not necessarily generating air pollution. It would really be tied to or because of on-site generation. Wastewater, the amount of wastewater that's coming from a data center might trigger the need for an EAW. And then again, with water appropriation, and that's if it's a commercial or industrial use greater than 30 million gallons per month on average being appropriated. But as Hudson said, EAWs don't often result in a decision for a need for an EIS. And there's really no precedent for an EIS being triggered at all, at least here in Minnesota, and let alone post an AUAR. So to show how this is working or not in practice, I want to give you a couple examples of data center proposals and how they seem to have gone through the AUAR and environmental review process. Next slide. So the first one is META's data center in Rosemont that has been approved. That's already under construction. This one's a little bit interesting because there were multiple overlapping issues. So around the same time, the city seems to have gotten requests for planned unit development master development plan with rezoning from META. It was called kind of underneath this gymnast title at that point, but was later revealed to be META. They also requested a tax abatement. And then at the same time, the city was due for an update to its 2018 AUAR. And because it was kind of happening all at the same time, at some meetings towards the end of 2023, the city decided to update the AUAR in a certain way. So that AUAR was published, and there was a comment period from December 5th to December 19th of 2023. I'm not sure how that amount of time comports with the AUAR's required 30-day comment period, but that's what happened. And then at some of these meetings, when they were discussing when to do the AUAR update, what needed to be what needed to be finalized before that was done, there were some interesting comments I just want to pull out made by some of the city admin. So in responding to a comment regarding the timing of AUARs, the city administrator noted that they can happen before or after development has occurred, which is not our understanding of how AUARs work, because they are an alternative form of environmental review. But as Hudson said, environmental review still needs to happen before development, before governmental action. The city administrator also said, once an AUAR is complete, future projects within the AUAR boundary do not require individual EAW and EIS documents. So I'm highlighting those two comments in particular just to kind of show, in addition to these things, how complicated this can be, an AUAR generally can be, how there might be a lack of understanding of what's actually required under an AUAR generally, but specifically for this kind of new development, because we're really talking about hyperscale data centers, the largest kind of type of data center that we know of right now. And so just to kind of pinpoint and show again that this is not easy. So the final AUAR was approved on December 21st, 2023. As far as I can tell, there was no other additional environmental review conducted. Next slide. So the other interesting one is Amazon's proposed facility in Becker, Minnesota. So I will just note at the top here, they have paused their plans for that, but they have not actually officially pulled out. I hear sometimes both that being said, but it's really just on a pause. So the city of Becker had a 2023 AUAR that does list data centers as a development scenario explicitly. So I think it's also interesting to note that in that AUAR, data centers, large data centers, are explicitly considered heavy industrial uses. Before this 2023 AUAR, interestingly enough, there was an EAW conducted in 2019 for a proposed data center within the AUAR. That was apparently triggered by mandatory EAW for industrial, commercial, institutional facilities. So that's, again, going to be given the location, the size of the city of Becker, and the size of the facility itself. But that land, so that was a previous proposal for a data center in 2019. Then, of course, there was the land changed hands a few times, plans changed. So this land was sold to Amazon in 2024. Amazon requested an exemption from the certificate of need process for its backup generators from the PUC, Public Utilities Commission, in December of 2024. The Public Utilities Commission determined that they do need to go through that process. They can't get that exemption. So that's part of what kind of put the pause on this. But I think there's a really big question about whether additional environmental review will be needed in the future, or does the 2023 AUAR that lists data centers as a development scenario, is that going to be sufficient? I think that remains to be seen. Next slide. And then we've been talking about the AUARs as the kind of main or most popular, most relevant in the news type of alternative review that's happening right now. But the Public Utilities Commission does have what's called standard review. Previously, before the law changed in 2024, this was called alternate review. But so this type of review applies to large electric power generating plants, not plants with capacities less than 80 megawatts. Similar plants that are fueled by natural gas, certain high voltage transmission lines, and then solar, wind, and storage projects. But just to really highlight, these are about energy generation or transmission. In the case of transmission lines, it would not apply to the data center itself. So this is just kind of an example of if a data center came up, this might be a part of the process, but wouldn't apply to the whole facility itself. So under this type of standard review, the alternative review is in the form of what's called an environmental assessment. Just took off the worksheet part of it. It's prepared by the applicant, not even just partially informed by, it is exclusively prepared by the applicant. And it only requires information regarding proposed projects' human and environmental impacts, and it must address mitigating measures. There's no additional information explicitly required under the law. There are public meetings and comment periods, but the comment periods are limited or only need to be open for at least 10 days under this review, 30 days for an EAW and EIS. But again, so final decision must be made within 6 months of receiving a complete application. That's also different for the timelines on EAWs and EISs. And then under this type of standard alternative review, this type of environmental assessment is the only state environmental review document that must be prepared for the proposed project. Next slide, please. And this is just a graphic kind of showing the difference between standard review, which is what we just described, and then major review, which follows the more traditional EIS path. Next slide. So where does all of what we've just shared with you leave us? There's a real lack of consistency between projects. I mean, even just looking at Rosemont and Becker, just two examples of recent data center proposed developments. And how they're handled by local governments, what kind of environmental review actually happens, when it happens, opportunities for public engagement. Mandatory category thresholds for triggering environmental review might not be relevant to data centers. Again, as we're seeing in Becker, the 2019 version, the 2019 EAW seemed to be triggered, yet the Meta facility in Rosemont wasn't triggered. Why is that? Would all data centers meet those thresholds, and when and why? I think that's an open question. Importantly, AUARs are only as good as the responsible government unit designing them. If there's a lack of transparency, so NDAs, non-disclosure agreements, have been very popular lately. That can cause an issue or a question about kind of how the RGU is designing its AUAR, and then also a lack of capacity. For smaller governments, they might not have the expertise, they might not have the staff available to really do a thorough job, host a lot of public comment periods or public meetings, and might lose out on some of that transparency or public engagement. There's also a limited guaranteed opportunity for public engagement or comment. Again, that's really limited to one. If you're following strictly the rules, there's only one 30-day comment period that is required. Cities can, and I know of some who have held more, but it's not guaranteed. So if you're looking for the bare minimum, it's only one. And then again, the AUARs are really meant for site preparation, not to replace review of a large industrial project. And then finally, there is no state agency permit that regulates data center development itself. So without one central permit that covers impacts across different media, so whether that's water, land, air, noise, light, communities, etc., environmental review will probably be scoped poorly because we're not looking at the full picture. And then finally, the PUC alternative process might apply, but because it would only be really specific to the generation on site, at least how it's envisioned now, it's not really going to get at the larger set of issues that might come around with a data center. All right, and then I think that's it. I think we're open for questions now.
Thank you so much, Sarah. And I'm sorry that for a second there, as I screen shared, I showed you a picture of your own face.
That's okay.
But you handled it like a pro. Yeah, so we have a few questions in the chat. They are all about EAW petitions, so I'm going to start talking about that. In fact, the reason that I accidentally did that screen sharing faux pas was that I was going to grab a resource off the internet, but I haven't been able to do that. Before I get to the questions, I will again say that if you're doing this for CLE credit live, the code is 543710. And if you are watching this as a recording, the CLE credit you would look for under code 543466. Awesome. So we have an anonymous question that says, who is alerted if there's a public comment period for an EAW? Do environmental watchdog groups review the postings and comment reliably? Others to lobby asking them to weigh in? This information is available from the EQB. It's called the EQB Monitor. You can subscribe to it. I think it comes out every week, and it is every official notice on an environmental review document in the state. Because of that, I receive that email, Sarah receives that email, you can receive that email. I don't know of anyone who reliably reviews it all the time and always looks, because many of them are for gravel pits or very local development projects. But that would be the way to do it. And to the extent that that's of interest to you, it is a statewide resource, so it'll often be about projects that are not in your neck of the woods. There are requirements to notify nearby landowners for particular things. So for example, for a zoning change, I believe that the requirement is like a quarter mile or a half mile. So there's different ways to receive notification. But if you want to know about every EAW in the state, you look for the EQB Monitor. And similarly, in regards to data centers where the RGU is the city and the petition goes to the original RGU and that results in nothing, is there a way to petition to the next higher RGU? I've seen this happen several times where the petition specifically says, we do not want this petition assigned to the city of Minneapolis because they clearly are not going to do an adequate job. And the EQB in that case, even the petition specifically said we would like this to be assigned to a state agency, and then it named 3 state agencies, and nonetheless it got assigned to the city of Minneapolis. So I do think that you can try in your advocacy for your petition to get it assigned to a more objective decision maker, but the EQB is going to do it's going to select the RGU based on which one is most appropriate. And usually they always make that selection based on who has permitting authority. So to Sarah's point, until we have a statewide agency that has a permit for data centers, then it will consistently be assigned at the local level because that is where most of the permitting authority exists right now. So it's a chicken and an egg problem. You can ask the EQB to change the way they assign RGUs. I would argue that you would be right in asking them to do that because picking a biased decision maker is not a good way to make decisions. But the real solution to that problem is to get a statewide permit for all data centers with a state agency that has the resources to do a good review. Got those 2 done. Another question on EAW petitions. Why do successful petitions go to my township, but not to my township, but instead to the county? My township has its own ordinances. Yes, my experience is it goes to the county in townships where the township doesn't have zoning authority. So it really depends on what type of project it is, right? But if it's a truly local project, and unfortunately data centers are often called truly local projects, it will probably go to whatever entity, the petition will go to whatever entity is issuing a conditional use permit or changing the zoning. So in the case of a city, that will always be the city. But if you're talking about an area outside of a city, that will either be the township if they have their own ordinances, or the county often will be the decider. Okay. Oh, here's a great one for you, Sarah. Are there initiatives underway to request a single regulatory oversight agency and require an EIS for data centers?
There sure are. Yes to both of those. So Cure, with several other organizations in Minnesota, does intend to bring forward and advocate for both of those things this year at the state legislature. I think it's, for all the reasons we just talked about, the lack of clarity is really not helpful for anybody, whether that's advocates, people who, are living or might live by a proposed data center, as well as the project developers themselves. Not having clarity about which agency they need to go to, it just complicates everything for everybody. So having a clear set of requirements, a clear process of what's required, I think would be an improvement for everybody.
Yeah, we have high hopes. High hopes. Um, Question about the Rusty Patch Bumblebee. How do we appropriately leverage the Rusty Patch Bumblebee in our local projects? Well, the state of Minnesota, University of Minnesota has a bee lab, which is full of people who know a lot about bees. So talking to the bee lab could be one way of doing it. You specifically want wild bee experts because honeybee experts aren't going to know anything about this. The Fish and Wildlife Service has a map. It is somewhat hard to find, but they have a map that shows where they believe the Rusty Patch bumblebees exist. Um, but that map, although helpful and illustrative, it won't necessarily be the deciding factor because for most endangered species, the Fish and Wildlife Service must designate actual critical habitat. And in the case of the bee, they have not done so as far as I know. So the map helps you get a sense of where the bees are found, but you would want to talk to an actual bee expert. And one thing you can do is this July, if you can talk to some really good bee experts, you could do a survey for Rusty Patch bumblebees in your community, which sounds like fun to me and also would be directly in service of protecting your community if you think your community has bees and you would like to have them protected. So definitely make plans to look for bees in July. They are hard to identify. There are lots of wild bees and they are endangered, so they are actually pretty hard to find. But it's a good way to waste your time in July. And not even waste your time. I shouldn't say that. That was too much of a joke. Um, so Sarah, how does a citizen get more up to speed on these environmental review worksheet options, or is it consultants or experts 90% of the time?
So the environmental worksheets, or kind of the environmental review that happens, like I said and Hudson said, like when they're actually created, those are pretty much exclusively done by the applicant or their kind of developer consultant, and then sometimes with kind of the responsible government unit or the state agency doing some additional work. But then if you're talking about like how do regular people read these and how do they figure them out? Yeah, you are. So you're, it's not really easy for regular people to do. So an EIS is often hundreds of pages long. There are some organizations like Cure that do for specific projects are engaged, and so we do our own kind of review of these things. But it's it's not the most public friendly way to go about things, in my opinion.
Yeah, and I'll echo what Sarah said. If you look at the rules themselves, a member of the public should be able to ask a series of questions and get an EAW or an EIS. The rules are very public friendly, and you should not have to be an expert to do it. But in practice, I have found that if you do not bring a certain level of expertise, often the RGU is looking for a reason to deny your application. And I don't mean to be bleak on that. I think different units of government will make different choices, right? But like if they're dead set against doing it, they might say, oh, this petition didn't have sufficient geological testing or blah, 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 things that only a consultant could do. And that is a barrier to entry, and I don't think that's the way the process should work. It does occasionally work that way, and it's something that might need to be resolved with litigation in order to make it clear that MEPA doesn't require such a high level of expertise. So this is a tougher one from Debbie. Permitting is in the news, trying to make the process less onerous. We want strong protections regarding data centers. Can we protect our communities and yet find a way to lessen time for environmentally sound actions? I'll let you answer that, Sarah. I have a
Sure.
lot of feelings about it.
Yes. Yes. I think it depends, I think everybody has different kind of maybe thresholds or beliefs in what should be maybe prioritized. But putting that aside, I think we find that oftentimes if a developer actually just goes through the process from the start, the way they're intended to, that's going to take less time overall because you're not going to be challenged on, well, should you have done the AUAR? We're seeing that right now with several lawsuits happening around cities doing AUARs for proposed data centers and whether those are sufficient. Might that whole process have gone faster if we instead did EAWs or EISs? I'm not sure. But I think sometimes just approaching it, knowing that if there are going to be potential environmental impacts, if they're going to be potentially significant, just doing that from the get-go is going to take less amount of time. You're also going to get a better response from the local community because it doesn't feel like you're kind of trying to shortchange them or their opportunities for public engagement. So I would propose just do the thing in the first place.
Yeah, and to agree with my colleague, these are the richest companies in the world and the richest companies that have ever existed. So complying with Minnesota law is not too hard for them. In the case of Amazon, when they initially applied to be exempted from an environmental review, they wasted 2 months on that. And then when they were told, no, you're going to have to do a basic permitting process under the law, they wasted, I think, an additional 3 or 4 months trying to get the law changed at the legislature. And then when they weren't successful at that, they said, we're going to take our ball and go home. And I don't feel too bad for a corporation that is saying that permitting is too difficult in Minnesota if they don't even try. Um, when you hear that permits are too onerous to get, that is often from people who don't know what they're talking about or people who just don't want to have to do what the law requires and don't want to have to admit that their project is going to have impacts on the community. So I do think it's a bit of a shell game where they say, oh, we just want to streamline the process, but what they really want to do is get rid of protections that we consider to be instrumental in making Minnesota a good place to live.
I can take the two on legislation real quick or on,
Yeah,
yep. So,
read them out
Cure,
loud.
yes, great. So, Cure is going to be at or some of our staff, probably me included, will be at the Capitol for the February 18th rally. I think timing wise, might have somebody present, might not, but we'll be there. We'll have materials out on a table. So yes, we'll definitely see you there. Regarding legislation, we're working on that. No bill, like things to report yet. No numbers, no bill authors officially yet. In talks with interested legislators. So that will be, stay tuned. That will be coming soon as well. And then I'm also just going to tackle this one on the status of the Geronimo Power one, because I was looking up some of that information in preparation for this presentation today or webinar today. So it sounds like they actually have started or entered into kind of a contract with a developer. I believe, don't quote me, I believe it's with Kimley Horn, but I would have to confirm that, to do an AUAR. But that's just, so it's just starting the process for an AUAR right now. And I believe that's being done by Geronimo, not Nobles County, which is interesting. So.
Yeah, great questions, everybody. Thank you so much for coming to our webinar. We will be doing one more on community benefit agreements. You are the first to hear that we probably are going to reschedule that one and push it out into March. So please check out our website about the new date for that webinar. and go back and look at the recordings of our other webinars. If you are watching this recorded for CLE credit, again, the code you will probably want to use is 543466. And definitely show up to the February 18th data center event at the Capitol if you're in Minnesota and so interested. Thanks for asking about that. All right, we'll just wrap it up. Appreciate everyone for coming.
Thank you all.